sorry.
No.
Who's going to be the spokesperson? Oh, I don't know.
I think we all do. I think we're the great chorus.
No.
Go, David.
Go, David.
Go ahead.
Who's the spokesperson? I heard David. David Coleman.
Your Honor,
Mr. Russo.
You know,
Go ahead.
who is going to ring in Miss Urich?
No, that's not a
She
public
goes up to
question.
the witness
Yes.
stand. She puts her notepad on the ledge where his hand is right there. Her notes while she's doing questioning of a witness. She walks over there and does this with the picture.
Yeah.
I mean, why is it that this prosecutor can't self-regulate like the other lawyers do in this room?
Why don't you describe the behavior you wish to address and don't attack the prosecutor? Remember, I'll give you a chance. Please let Mr. Russo. I don't want personal attack. Tell me the behavior that you are observing.
It's not personal. I like Miss Urich. But when I get in trial with her, I don't like her.
What's the behavior?
It's not personal. It's business.
Tell me what
The behavior is an extension of intentionally letting the cat out of the bag the first day within her opening statement. That's been worked through, but it's an example of similar behavior. She puts her notepad up on the ledge next to the first juror, which I'm sure someone would be tempted to look at the very least. These are the kinds of things that lawyers should have to be told not to do.
Be specific. Number one, you are alleging that. No, please, let Mr. Russo.
Okay, she puts her notepad up on the ledge. That's another thing. And this photograph that she just starts parading around, she was just, oh, excuse me, a little bit careless, and turned it at an angle where the jurors certainly could have seen had they looked that way or wanted to. She should be engaging.
No, don't tell Ms. Urich what she's supposed to do. Just tell me what behavior you wish me to do.
Okay, those are the two levels of behavior. I think there may be others that can describe in detail also.
Mr. Yankee.
Your Honor, Ms. Urich walked over here with a photo, flashed it, photo side towards the jury, and then turned it around to face the counsels. I don't know whether this was deliberate or not. It certainly seemed to be. I couldn't tell you, but I mean, the jury could have gotten a clear glimpse. I'm sure they did. It's clearly from looking at it a booking photo with a photo. Excuse me.
Any other behavior? I got that part. Mr. Russo.
That was the behavior. It was displayed quite openly, quite obviously, and the jury is paying attention to her because she's asking a question and moving around. There is no way that at least some of those jurors did not see the picture and what it was. Actually, it's a new one. We now have a new motion for a mistrial because this cat is out of the bag. These records are inherently prejudicial. A booking photo is presumed by the average member of the public to indicate that someone was arrested and is guilty of doing something. It has information on it that's highly personal, and I'm sorry, Ms. Urich seems to be flouting the rules over and over. We would ask for a mistrial. We would ask for sanctions against Ms. Urich, separate from a mistrial, and we would ask for a dismissal of this case. I've never seen anything like this.
Does anyone wish
Your Honor, I joined the motion for mistrial.
Okay, one at a time. Mr. Smith.
I join the motion for mistrial based on the cumulative effect of all of these examples of misconduct that Mr. Russo had earlier described. I think if not one of them would be sufficient to lead to a mistrial, certainly when taken in total, I think they're more than sufficient. So I would ask for a mistrial.
I would join you in that, Your Honor. The photo that was shown was that of Nicholas Bland, who I'm representing in the absence of his attorney. His picture, his booking photo, has now been shown to the jury. That is highly prejudicial to them. It's not even been admitted. The foundation hasn't even been laid down for the purpose of this whole thing. So on behalf of Mr. Bland specifically, because it was his photo, and on joining with all the others, I'd ask for a dismissal or at least, Your Honor, a mistrial.
Yes.
Yeah, I'd just like to join in and second all the motions. And I was sitting right here. She was bringing the photo to my attention as she flashed it towards the jury. So I had a front row. I witnessed this front row, and it was as blatant as possible in my perception. So I just
would like to join in on the motion as well, Your Honor. Ms. Urich was informed about the defense's concerns just a few minutes prior to the entry of the jury, and yet she proceeded to flash the booking photo in a way that was quite careless and possibly deliberate.
Anyone else wish to add anything? Yes, Ms. Porter first.
Hey, Mr. Joyce.
All right, Mr.
Your Honor, I join and I just note that immediately proceeding discussion regarding the issue.
Ms. Porter, do you want anything to add? No? Are you
I'd like to
well,
speak
wait,
on this.
Mr.
Done here.
Son.
I join too, Your Honor. I have a fear she may do the same thing with other booking photos, including mine.
Will you speak with her?
Yes, I am, Your
All
Honor,
right.
especially since the comments from the person is your
Well, I would like to consider the comments not in a personal way, but rather addressing the behavior that appears to be problematic.
Your Honor, first of all, let's address the issue. We have people either who are counsel, who are our acting counsel themselves, presumed to know the rules and how the procedure is in this courtroom. They know that Ms. Urich has to publish these items to them before admission. The attorneys certainly know the procedure. And if they raised the concern, Your Honor, about how these items were shown to them in advance, they should have done it before this issue was brought about. If there was such a great concern, at least the attorneys are experienced enough to know that they could ask the court for a different procedure. They chose not to. Now, talking about the laying of her notepad on the jury bar there, I find that particularly interesting, coming from Mr. Underwood. I'm going to. No, Your Honor. Let me.
I just want to say, Your Honor, that I did not bring that up, Mr. Strawman. I didn't bring it up specifically because I do it.
That's exactly it.
And that's why.
Well, wait a second. We're not talking about defense counsel. We're talking about some allegations about what you said.
But he also used the bar as a resting pad. Nobody objected to it. Nobody accused him of trying to do anything untoward toward anybody. And number three, with regard to the issue of the cumulative effect of mistrials, first of all, counsel is bringing up the whole allegation of the fact that Ms. Urich somehow was inappropriate at the time of the opening statement. She indicated to the court she believed she was following the court order. She pointed to the court specifically where she was. Her conduct was not in violation of that court order. The court invited individuals to look at the record and to see if she somehow violated the court order. They did not come back to the court, so that shouldn't even be considered. A mistrial was not granted, and the cumulative effect certainly is not at issue here, Your Honor, because they have not shown that she has acted improperly for this time, Your Honor.
I'd like to, since that was directed at my argument,